One of the more significant issues in today's music industry is that of sampling. It is a term that crosses all areas of music from songs, records, films, television, theater, commercials, and beyond. There are many definitions of the word sampling. In briefest terms, it is when a songwriter, recording artist, or record producer takes a portion of an existing song, existing recorded performance, or both, and integrates it into a newly recorded performance. Overview. Sampling can take a number of different forms. The following are the most common. The song itself. The recording artist or record producer uses an instrumental portion, e.g. guitar or bass line or full instrumental track, of an existing master recording and inserts it into a newly recorded master. The master recording and the song. The recording artist or producer transfers an existing master recording and vocal performance of the song directly into the newly recorded master. In cases where the producer supervising the session, remixer, or recording artist samples without permission from the music publisher, the owner of the underlying song sampled, the publisher and record company will contact the recording artist or record company that releases the unauthorized sampled performance and advise that such use constitutes an infringement of copyright. A demand will also be made that the infringing party cease and desist all activities related to the sample, that all product be recalled from the market, and that damages and profits be paid immediately. In these instances, the matter will either proceed to litigation or, if a settlement is negotiated, will be resolved through a continuing monetary or copyright participation on the part of the sampled publisher and/or record company, or a release of claims in settlement that results in a monetary payment by the sampling party to the sampled party, and many times an agreement that the sample will be deleted from any and all recording made and distributed in the future. In cases where the recording artist, producer, or record company request permission prior to the actual sampling or release of the recording which incorporated the sample, the applicable /music publisher, record company, or both will, if the uses is approved, usually negotiate a settlement of the matter. If the sample is not approved, the sample can be deleted from the recording before it is released without any harm to the recording artist, record producer, and recording company. In this regard, and as a piece of practical advice, if permission to utilize a portion of an existing composition or recorded performance is requested by the sampling party prior to sample being recorded or released, the owner of the sampled composition or sampled recorded performance is or likely to view the new recording in a positive manner and be amenable to a non-litigation resolution. If the sample is approved, resolution is handled in a number of different ways, including a one-time buyout of all rights fee, the payment of a percentage of income received from either the new recording or the new song, or the transfer of a portion of the copyright of the new composition, plus the income generated. As a composition or master recording will request a copy of the new recording for review, time the duration of the sampled section, review how the sample has been used, and determine its importance to the new version. There are no hard and fast rules in this analysis, and final resolution is usually based on, among other things, the bargaining power of the parties, the duration of the sample in comparison to the duration of the entire new recording, although timing may have little relevance if a key element or recognizable piece of the original composition or recording has been used, the nature of the sample, i.e. whether a core portion has been utilized or just an incidental portion, whether it reoccurs during the new recording or is only used once, the content of the non-sampled elements, for example the theme and/or other lyrics of the new song, the actual sales of the new version if it has been released, whether the new version has reached the charts and whether the sampling party requested permission. If the sample has been approved, negotiations can take a number of different forms. For example, the publisher can grant the owner of the new composition a worldwide license to use the sampled composition for an agreed-upon share of the mechanical royalties generated by sales of CDs, downloads, and other audio configurations embodying the new composition. Under this type of arrangement, the publisher and writer of the sampled composition normally receive from 10% to 75% of the royalties generated, but such percentages can be higher or lower depending on the facts of a particular case. Occasionally, these payments will be made on a so-called rollover advance basis, e.g. $2,000 for the first 50,000 recordings sold, $2,000 for sales between 50,001 and 100,000 units, and additional $2,000 for sales between 100,001 and 150,000, etc., or an advance against a specified number of units will be given to the publisher of the sampled composition. For example, if the sampled publisher secured a 50% interest at a statutory rate, an advance of $4,550 might be requested to cover the initial 100,000 units sold. At such time that sales reach the 100,000 level, the sampled publisher would start receiving mechanical royalties on a per-unit basis for future recordings sold because the prepayment advance had already covered all royalties that were due for the initial 100,000 sales. On the other hand, if the recording never achieved the 100,000 sales plateau for which the advance was paid, there would be no reimbursement required since most advances by their nature are non-returnable unless negotiated to the contrary. Sometimes non-recoupable fees may also be paid for use of the sample. If a share of the copyright ownership is negotiated, the publisher of the new composition will transfer a portion of the copyright, e.g. usually from 10% to 75%, but it can be as much as 100%, to the publisher of the sampled composition. In addition, the names of the songwriters who wrote the sampled composition will be added as writers and will receive credit on all uses of the new composition. Under this type of arrangement, the publisher and writers of the sampled composition will receive a portion of all income generated by the new composition. For example, if the new composition is licensed for use over the opening credits of major motion picture, the publisher and songwriter of the sampled song would not only receive a portion of the synchronization and video buyout fee negotiated for the use, but would also receive their proportionate share of all income generated from all other uses generated by the film, e.g. mechanical royalties from sales of the soundtrack album or, if applicable, soundtrack single, performance royalties for television broadcasts of the film, radio and television performances of the song from the film, foreign theatrical royalties, advertising commercial fees, sheet music and folio use, interactive media, lyric reprints and novels, karaoke, streaming royalties, etc. The screen credit is for the new composition. We'll also mention the title of the original composition, its writers and in some cases publisher information. Even if permission for the sample is approved, restrictions may sometimes be placed on how the new composition may be restricted from being placed in a motion picture, television program, or video unless the writer and publisher of the sampled composition gives their approval. There also may be restrictions on the use of the new composition in commercial advertising campaigns as well as technology uses. Many times, the writer and publisher of the sampled composition will, in the case where the sampling writer is either a recording artist or record producer, agree to be bound by the terms of the controlled composition clause of the recording artist or record production agreement. For example, if the sampling writer/artist has agreed to a 75% mechanical rate for all physical albums sold in the United States, the publisher of the sampled composition may also agree that its share of royalties will be calculated on the same reduced rate. In many cases, however, the publisher of the sampled composition will demand that its share of royalties will be calculated on the same reduced rate. In many cases, however, the publisher of the sampled composition will demand that its share of royalties be based on the statutory mechanical rate regardless of the reduced controlled composition rate agreed to by the recording artist or producer. This latter arrangement is very common and can have a significant negative impact on the royalties due the writers and publishers of the non-sampled portion of the composition. For example, if a writer/artist is subject to a controlled composition clause that dictates a 75% reduced rate mechanical license for a composition contained on physical product, $6.825 in 2018 to 2022, and the publisher and writer of the sampled composition demand not only 50% of the copyright and income but also 100% statutory rate for their share, $9.1 * 50% equals $4.55 $2.275, and if the publisher of the sampled compost-ion licensed its share via a floating statutory rate basis, which would get the benefit of any future increases in the statutory mechanical rate, the writer/artist mechanical income would continue to decrease as the sampled composition's mechanical rate increased. This is because the writer/artist's 75% controlled composition rate is locked in as of a set date and does not change regardless of industry-wide mechanical rate increases. As to performance income, the performing rights organizations will follow the percentages agreed to in the sampling agreement and will remit royalties accordingly. For example, if the parties agree that the sampled composition was entitled to a 60% of the songwriter royalties due from performances of the new composition to the writer of the sampled composition and 60% of the publisher's share of all performance royalties to the publisher of the sampled composition, The remaining 40% writer's share and corresponding publisher's share of income would be paid to the writer, and publisher's share of income would be to the writer and publisher of the new composition. These splits are set forth in the song registrations submitted to the performing rights organizations ASCAP, BMI, SESAC, or GMR by the music publisher. Since worldwide radio and television performances for chart songs can range from $400,000 to over $1 million, the negotiations as to royalty shares between the sampled composition and the new composition can have a very significant financial effect on all of the writers and publishers involved. In most cases, the publisher of the sampled composition will administer its own share of the new composition throughout the world with direct collection of royalties from all sources. Format of the sample agreement. A sample clearance/permission agreement can take many forms, but the major areas of consultation which are dealt with are as follows. Copyright registration. If a portion of the copyright in the new composition is being transferred to the music publisher of the previously existing sampled composition, an occurrence which is the norm and not an exception to the rule, the parties will provide for the registration of the new composition in the Copyright Office of the United States via a registration that reflects the mutually agreed upon ownership percentages. For example, if the ownership split is 50% to the publisher of the existing sampled composition and 50% to the publisher of the new material, such will be stated in the sample agreement. If the publisher of the new material has already registered the new composition in its own name, an assignment will be prepared to transfer the appropriate share to the publisher whose composition was sampled. The publisher of the sampled composition usually has the right to sign such an assignment on behalf of the sampling publisher as its attorney. In fact, if the sampling publisher does not do so within 10 to 20 days after request to do so by the music publisher of the composition sampled. Administration of the new composition. In many cases, each of the publishers will have the right in the United States and Canada to administer and exploit the new composition as well as enter into license agreements for the new composition, provided no such licenses are exclusive and no mechanical licenses are issued at less than the statutory mechanical rate, with reduced rates being permissible only for those types of sales for which music publishers customarily grant reduced rates to non-affiliated record companies. The sampled publisher usually demands that there will be restrictions placed on certain agreed-upon types of commercial exploitation of the new composition and will provide its share of the new composition not be subject to or adversely affected by any controlled composition clause in the sampling writer/artist or writer/producer recording artist or producer's agreement with a record company, and that synchronization licenses, advertising commercial licenses and other such licenses only be issued jointly by the sampled publisher and sampling publisher, with approval to be withheld in either party's sole discretion. Under this common scenario, if a motion picture producer, television producer, or advertising agency wants to use the new composition in a motion picture, television series, or commercial, they must negotiate with both the sampled publisher and sampling publisher for the right to use the new composition. In addition, the sampled publisher and sampling publisher will agree to instruct all licenses that the licensee will remit each party's respective share of monies directly to that party, and that a copy of the signed license will be sent to both the sampled publisher and sampling publisher. For example, if the negotiation of a motion picture license fee for the new composition results in a fee of $40,000 and the agreed-upon money split is on a 50-50th basis, the film producer will send $20,000 directly to the sampled publisher and $20,000 directly to the sampling publisher. Collection of monies/payment of songwriter royalties. Each of the publishers, both the publisher of the sampled composition and the sampling composition, will agree to collect its share of income directly from the source, or through their respective sub-publishers as to foreign income, including mechanical royalties from both physical and digital distribution, the publisher's share of performance income, streaming income, synchronization fees, video royalties, print income, and all other miscellaneous royalties generated by the new composition. In turn, both the sampled publisher and the sampling publisher will guarantee that each will be responsible for the payment of songwriter royalties to the respective songwriters signed to them. On occasion, if an affiliate or subsidiary of one of the publishers is a print company, there will be a stated royalty which will be deemed to be the gross royalties payable for various print configurations. For example, all parties might agree that the royalty for each copy of regular sheet music will 20% of the suggested retail list price. The royalty for folios or songbooks which contain the new composition and other compositions will be a pro rata share of 12.5% of the marked retail selling price, and the royalty for fake books and educational, orchestral, choral or band arrangement editions will be 10% of the marked retail selling price. Additional sampling. The writer and publisher of the new material will guarantee the original songwriters and the publisher of the sampled composition that no other existing compositions have been sampled in the new composition. The sampling writer and publisher will also indemnify the sampled publisher against any claims from a third party that its composition was sampled as well, and will agree that, in the event another composition was sampled and a share of the new sample has to be assigned to the publisher of the additional sample, that such share will only be deducted from the sampling publisher's share of the new composition. For example, if one sample takes 50% of the copyright and income of the new composition and it is discovered that there is an additional sampled composition is contained in the new composition, the copyright and income percentage given to the publisher of the additional sample will only be deducted from what remains after the share of the other sampled composition has been deducted. The obvious danger in these situations when more than one pre-existing composition is sampled in the composition is that the publishers of both sampled compositions might demand 50% of the new composition, leaving the writer and publisher of the new composition with 0%, or, even worse, a demand by each of the sampled publishers for 75% or more of the new composition, leaving the writer and publisher of the new composition with at a minimum a minus 50% more than is actually earned. In these situations, the irony is that it is sometimes better to have a failure rather than a hit, since as more royalty-generating albums, singles, and other recordings are sold, the payout to third parties gets larger and larger. The variations in this area are innumerable, and the calculations as to who owns what and who is entitled to what and where the money is going are limitless. Suffice it to say that one needs a calculator at all times when dealing with the issues involved in sampling, as it is relatively easy to give away more than you get if you are the writer/artist or writer/producer doing the sampling. Conclusion. One of the main financial and copyright dangers of sampling to the party who is doing the sampling, and this is not an exaggeration, is the possible loss of 100% of the income from the new composition, as well 100% of the copyright ownership in the material newly created by the artist/writer or producer/writer that is part of the new composition. For example, some writers and publisher of existing hit songs demand 100% of all rights in the new composition that is sampled an existing hit song. This includes the copyright, the administration rights, the right to license the composition and collect all royalties, all songwriter royalties, including performance income from radio, internet, and television airplay, and all publisher royalties, including record sales, downloads earnings, advertising commercial fees, motion picture use fees, television synchronization income, and video game and ringtone payments. This worst-case scenario for the writer/artist or writer/producer doing the sampling does occur, and you have to be aware of the fact that the bargaining power in the negotiations is totally in the hands of the owner of the composition being sampled. Clearance of samples prior to a recording being released or otherwise used is essential.